2022 CR 3597, State of Texas versus Chardonnay Leanne Lockhart. Ms. Lockhart?
Yes.
All right, they're charging you as arson as a Class A misdemeanor. The range of punishment for that offense is up to $4,000 fine and up to a year in the Bexar County Jail. Do you understand?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
If I could answer a little bit more, Your Honor. Yes, I do believe she does. She's mentally competent. She was done a psych evaluation for competency a few months ago. She has been found competent after discussing the case with her today and last week as a jail visit. I agree she is competent.
All right, so she's already been to the magistrate's court and they've deemed her competent?
That's correct, Your Honor.
All right, do you believe she was sane at the time of the offense?
Yes, Your Honor.
Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, sir.
Okay, according to the plea, the state is proceeding on the lesser included offense of attempted arson recklessly causing damage. They're recommending deferred adjudication. They're taking in consideration county court cause number 634806, and there's to be a MIC evaluation. Did you understand that to be the plea?
Yes, sir.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Next, I'm showing you outside the plea bargain agreement. State is recommending that your deferred adjudication be for a term of 2 years and there be a TAP evaluation. Did you understand?
Yes, sir.
Okay. Did you understand that those are recommendations from the state and the court does not have to follow those recommendations?
Yes, sir.
All right. Then to the offense of attempted arson recklessly causing damage, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State offer state exhibit 1 in all attachments.
No objections.
Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Ask to follow the plea bargain.
All right, Ms. Lockhart, if you're released from custody, do you have a place to live?
Yes, Your Honor.
Where?
738 North.
No, I'm sorry, don't say the address,
Oh,
but who will you be living with?
I apologize. It's a property my father had bought me.
Sorry, what?
I'll be living by myself.
Well, whose property is it?
My father.
Why were you not living with your father before? During this incident?
No, it's because I'm 30 years old.
Well, no, here's the thing. I'm reading this and it appears, rightly or wrongly, the way I'm reading it, it appears that you were homeless. It says that you started this fire because you were trying to dry a blanket. So I'm wondering why you were not living. Well, no, that's what they say you told them. It's in the police report. So I'm trying to figure out why were you homeless and why would your father let you live with him now?
Judge, if I could just have a second.
Here's the thing, Ms. Lockhart, you need to be honest with me because I'm trying to figure out your conditions. And let me just tell you, 1 or 2 things are going to end up happening. If I don't believe you're going to be honest with me, this is going to be set for a PSI. You're going to be sent back to the Bexar County Jail. They're going to do a PSI report and I'll get it when I get it, which will probably be within 8 weeks. So you need to answer my questions and you need to answer my questions honestly. Now, in this police report, basically it's implying that you were homeless because it said there were clothing and other items and that you lit this fire because you told them you were trying to dry your blanket. So this is what you stipulated to. I didn't force anybody to stipulate to it. That's what's in the police report. So why were you homeless if now you can live with your father?
I wasn't at home, but I was not homeless.
So why were you living in this field or wherever it was with your items?
I have no idea. I don't know how to answer that.
All right, so why is she wearing yellow today?
I'm pregnant.
Okay, I just wanted to hear it. And how far along?
Like 21, 22 weeks now.
Okay.
Judge, I didn't mean to be presumptuous, but I have been in this court once or twice before. I did tell her she was going to be taking a parenting class, which was theoretically outside of it, but she understands she's going to take the parenting class going forward. Because that's going to be her.
All right, and is she on medications at the jail?
Yes, Judge. She was not on her medication at the time. Now she is on her medication. She's frankly alive. She's definitely competent at this point in time. At the time, she was not being rational. But at this time, she is going to be successful going forward. There is a part about the mental MIC caseload and her being interviewed for that. I believe that would be necessary. And she understands that being med compliant is going to be a part of that as well.
All right, do you have any other children?
Yes, I do.
How many?
2
And where are they?
out of town with my family.
And what are their ages?
11.
They're both 11, twins? That's either yes or no.
Yes.
All right, this is what, is there anything else from either side? Do you know if she's receiving SSI now?
I don't know.
All right, I'm gonna sentence you to 2 years deferred adjudication. I'm gonna want felony drug court referral. They should be able to do it because it's 2 years. And I'm gonna want a MIC evaluation. Those are to take place while in custody. And then I'm gonna want a referral. If she's not approved to MIC, I want a referral to Center for Healthcare Services, parenting classes. Take in consideration County Court cause number 634806. 80 hours of community service restitution. Once she completes parenting, that will be satisfied. Regular reporting by Zoom or in person. Regular UAs. And I'm gonna want a TAP evaluation in custody as well. If TAP recommends inpatient treatment, we'll start her with intensive outpatient treatment. And I'm gonna want field visits 1 time per month until further notice. Probation, we'll do proof of employment within 30 days of release, or proof of SSI within 30 days. There's to be no employment as a home health care provider or with minors. And I'm sorry, instead of the regular UA's probation, I'm gonna want the UA hotline with testing at least once a week. Probation, is there anything else she needs? Is there anything else you need from the court to be successful?
No, Your Honor.
Counsel, do you think there's anything else your client needs?
There's nothing else she needs, Judge. We asked the evaluations be done when she's out in custody.
All right, that will be denied. All right, we can go off the record. Was she not approved for mental health court?
Honestly, can't tell you off the top of my head, Judge. Since she's been in custody this time, we've conferred with the DA, and this is the attempt. She's got quite a bit of time. So this is our agreement that we reached.
All right.
She was approved. I know that she's being evaluated for mental at the MIC caseload. Being that it's a misdemeanor, but mental health court, I don't think that was the approach because there wasn't an option to be a misdemeanor until we talked about the last week.
All right, probation, can you also do a referral to the mental health court? And see if they'll accept her. My understanding, mental health court, it's sort of like PTD. So if they accept her and she completes it, then this will be as though it never happened. So counsel, if they accept her in PTD and you all want to come back and ask for a motion for a new trial or withdraw her plea, then the court will consider that.
That's what I was thinking ahead, Judge. That's why my brain was going like, I don't know if it looked like I was rolling my eyes. Does that mean that she wants? Yes. Okay.
All
I'll
right,
explain that.
so,
Thank
Rashawn,
you.
if you can, you're welcome. Rashawn, if you can make sure she's referred to mental health court and tell them that even though she's entered a plea here, if they are willing to accept her, defense is going to file a motion for new trial and the court will grant it. All right, thank you. You're welcome. Have a great day. Court is calling 2022 CR 3597, State of Texas versus Chardonnay Leanne Lockhart. Can I have parties announced for the record for the state?
Again, U.S. Court for the State of Texas.
Defense?
Mark Darling for the defendant.
And are you Ms. Lockhart?
Yes, ma'am.
Going to show you a document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am, I did.
Are you the same Chardonnay Leanne Lockhart who was placed on deferred adjudication in 2022 CR 3597 for the offense of attempted arson, reckless causing damage on May 15, 2023 for a period of 2 years? Is that you?
Yes, ma'am.
All right, state.
Violate condition number 4 in Bear County, Texas. The defendant, Chardonnay Leanne Lockhart, then and there failed to report to the supervision officer as directed for the months of August and September 2023 in violation of condition number 4.
How do you plead to that? True or not true?
Your Honor, the state waives all the violations.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 1 year in the Bear County Jail and up to a $4,000 fine? Did you understand that?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, Your Honor, the proposed agreement is for 272 days in the Bear County Jail and for this to satisfy the judgment, since it's a Class A misdemeanor.
All right, has she done anything on probation?
No, Your Honor.
All right, then why would, well, all right, so you've done nothing on probation. Probation, what are you requesting?
After she was here last in court, she just did not show up anymore. So we understand that there may have been or may be some issues as far as possibly homelessness and so forth. And we were going to ask just to amend for a moral recognition therapy, job skills training, and possibly the reentry center for services.
And will this be set up while she's in custody if I follow this?
We can't set up those things in custody, Judge.
All right. Miss Lockhart, can you raise your right hand for me, please?
Yes, ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Chardonnay Lockhart.
All right,
Chardonnay Leanne Lockhart.
all right. Miss Lockhart, what's the status of the pregnancy?
I'm not pregnant any further.
Okay,
Judge,
I mean, how do you mean?
okay. All right, so here's my issue. I don't know if anybody wants to ask any more questions, but I'm not going to give her 272 days in the Bear County Jail. If she wants to be revoked, she can be revoked. I'll give her 365 days at the Bear County Jail, or she can, or I will follow the probation's recommendation.
You understand? Do you agree? Judge, it's Ms. Lockhart's wish that you do sentence her to 365 days in the Bear County Jail after revocation versus the alternative, she doesn't wish to make
Right,
those
it'll be a
efforts.
$4,000 fine, and time and money is not going to run concurrent.
Well,
Because let me just tell you, Ms. Lockhart, here's what the problem is. The problem is that you're on deferred for an attempted arson. You're homeless. You have no job. You've been staying from hotel to hotel. You're going to end up potentially, if I just send you out in the world, you're going to end up getting another theft case or something else is going to end up going wrong with your life if you don't get stable. The only thing that I can do other than continue on probation is maxing you out. And the reason why I would max you out is because you have done nothing. And the reason why I will not run time and money concurrent is because you have done nothing. So the choice is yours.
I paid them.
yeah, I'll tell the judge.
Yes, what would you like to do?
Okay, I would like to do the 365 and pay the $4,000 fine.
Court will grant the motion, find you guilty, sentence you to 365 days in the Bear County Jail, give you credit for any time served, there's a $4,000 fine. Time and money is not to run concurrent. All right, good luck to you.
Thank you.
You're welcome.
This courtroom hearing followed the difficult journey of Chardonnay Lockhart, a woman struggling with mental health challenges, homelessness, pregnancy, and probation violations. At first, the judge showed remarkable compassion by giving her an opportunity to avoid a criminal conviction through deferred adjudication and extensive treatment programs. However, after Lockhart failed to follow even the most basic conditions of probation, she returned to court facing the consequences of those decisions. The hearing ultimately demonstrated that while courts are often willing to provide second chances, those opportunities require effort, honesty, and personal responsibility. The hearing began with Lockhart appearing before the court on a charge originally filed as Class A misdemeanor arson. Before accepting any plea, the judge carefully confirmed that she fully understood the charge against her and the possible punishment, which included up to 1 year in the county jail and a substantial fine. Because Lockhart had previously undergone a psychological evaluation, the judge first wanted to ensure she was mentally competent. Her attorney explained that she had already been evaluated by mental health professionals and had officially been found competent to stand trial. After meeting with her several times in jail and discussing the case thoroughly, her attorney confirmed that she understood the charges and was capable of making legal decisions. Satisfied that competency was no longer an issue, the judge reviewed the negotiated plea agreement. Rather than proceeding on the original arson charge, prosecutors agreed to reduce the case to the lesser offense of attempted arson involving reckless damage. In exchange, they recommended 2 years of deferred adjudication, allowing Lockhart to avoid a permanent criminal conviction if she successfully completed probation. When asked how she wished to plead, Lockhart entered a plea of no contest, allowing the court to move directly to sentencing. Before announcing punishment, however, the judge wanted to understand Lockhart's personal circumstances. The police report indicated that officers believed she had started the fire while attempting to dry a blanket and suggested she had been homeless at the time. The judge questioned her directly. If her father owned property where she could now live, why had she apparently been living outside when the incident occurred? Lockhart struggled to explain. She insisted she was not actually homeless, but admitted she had not been living at home either. When the judge pressed for details about why she had been staying in a field surrounded by personal belongings, Lockhart simply responded that she did not know how to answer the question. The judge emphasized that honesty was critical. If she believed Lockhart was hiding information or refusing to answer truthfully, the court would postpone sentencing, order a lengthy pre-sentence investigation, and send her back to jail while the report was completed. The judge explained she was trying to determine whether probation would realistically succeed. During the discussion, another important fact emerged. Lockhart was approximately 22 weeks pregnant. Her attorney informed the court that since being incarcerated, she had resumed taking her prescribed mental health medication. According to the defense, she had not been mentally stable when the offense occurred, but now that she was receiving proper treatment, her condition had improved dramatically. The judge also learned that Lockhart already had 11-year-old twins living safely with other family members. After considering all of the information, the judge decided to give Lockhart an extraordinary opportunity. Instead of imposing jail time, she placed Lockhart on 2 years of deferred.